Hi there, thanks for joining today. We're here live from Houston, Texas at the offices of Reddy and Neumann PC. My name is Emily Newman. I'm an immigration attorney and partner with Reddy and Neumann PC and also the writer behind immigrationgirl.com. I'm here with my partner today, Rahul Reddy.
Hi, this is Rahul Reddy. I'm practicing immigration law from 1995. We established our law firm in April 1st of 1997. It's been 21 years. We're going to go live today, just like every week. We're going to bring live the immigration news every week, live at 5 Central Time. Emily, now we have the big things coming up. The new year for the immigration starts on October 1st. It's not January 1st. So we have this new year coming up. So there are some issues that we need to cover, mainly what's going to happen for those cap gap people who are allowed to work until September 30th. And if the H1 is not adjudicated after October 1st, they cannot continue working after October 1st. What are the options they have? Can they stay in United States? Can they apply for some employment authorization?
Yeah, so this is particularly for cap gap students. So for F1 students whose OPT expired between April and October, whose H1B was selected in the lottery but not yet approved. So the cap gap regulation only allows for employment authorization through September 30th, meaning if your H1B is still not approved on October 1st, you're no longer authorized to work. So you have to stop working from October 1st unless you have some other authorization to work. Now, just because you have to stop working does not necessarily mean you need to leave the country, because once you have your H-1B filed requesting a change of status, that puts you in a period of authorized stay based on the pending application. So you can remain in the U.S. while you're waiting for the result of your H-1B, but you have to stop working on September 30th. Now, do you have other options to continue to work? Generally, not really. How about the day one CPT? I can get admission in a university and I can get the CPT. Is that not allowed? Well, we've talked many times about the kind of CPT being used for improper purposes, for being provided after someone has already completed OPT at the same degree level, being provided from before the 1-year requirement for grad students. So there's a lot of CPT out there that's not properly authorized in the eyes of USCIS, and they're actually denying the change of status request from F1 to H1 for people who do that. So if you are thinking CPT is a good backup plan from these day one programs, I would urge you to second guess that option and to avoid it, because it may ultimately put you out of F1 status and then make you ineligible for the change of status and unlawfully present from the day you start. Now we have the unlawful presence memo that went into play on August 9th specifically for F1 students that says that if there's a determination made that you violated your F1 status, such as by using improper CPT, that causes you to be unlawfully present, not from the day they make the decision, but from the day you started that unlawful activity. So if you end up 6 months from now with an H-1B denial because of the status violation of F1, then you're going to be barred for 3 years because you chose to use that CPT program. So I think that maybe there's a short-term gain there in that you might be authorized to work, but the long-term impact is not worth the risk of taking those programs.
Yeah, we also want to give an update for the H4, as we have published an article on the litigation issue. At this point of time, the administration is contemplating to issue proposed regulations, most probably restricting the H4 EAD. They should be coming anytime before end of this year. That's what they said. Now, however, previously they said it's going to be June of 2018, but now most probably their regulations are going to come before December of 2018. Now, What is going to happen with the applications which are in the pipeline? What is going to happen with those EADs that are already approved? Now, we yet don't know how the administration is going to act, but based on the previous history of the administration, when they have taken off the employment authorization for the undocumented aliens in United States, those are called DACA kids, they allowed the people whose EAD was expiring within 3 months period to be allowed to file the extensions. They said the EADs that are already there, they are valid until they are being expired. And of course, there's a litigation on that, and I'm not going to go into detail. So most probably for the H4 EAD, when these proposed regulations are going to come, we are expecting that they will show the same courtesy what they have shown to the undocumented aliens. So if at this point of time you're eligible for the EAD extension, or if you're eligible for the EAD, we urge you to file for the EAD or EAD extension. Now, when the proposed regulations are going to be published, we are going to come as usual. We are going to be live every Tuesday at 5. You can always log in so that you can get the update of what's going on in the H4 EAD. Any other updates on the H4 EAD from you?
Yeah, so Sarah Vanan has a question about that exact issue. You know, if you're filing an H1 transfer, do you have to file an H4 and H4 EAD with it? No, you don't have to, but it's a very good idea to do that so that the EAD can be issued for an extended validity. So if you are filing a transfer, even if you're maybe filing an amendment, if plus extension, if the H1B approval will provide longer validity than what you currently have, then the H4 EAD would also get that longer validity, and it may be a better option to file it now rather than wait too long to where you don't have the ability to later.
And also that if when the H1B premium processing is going to be resumed, we're assuming it's going to be resumed in February. If the H4 and EAD is going to be filed together, they most probably would be adjudicated at the same time. If you're going to file H4 and EAD separately, it might take a long period of time, and there was never a premium processing for H4. So that's an additional point that they need to look into.
Yeah, so with this, coming proposed regulation, so we're thinking December, we might actually see the proposal. What do you see as the timeline for getting through the whole rulemaking process and a final rule actually being issued and taking effect?
At the minimum, I'm thinking, Emily, once they publish the proposed regulations, they'll give 30 days for us, and then for the comment period. And after 30 days, they normally take about 90 days to come back and issue the final regulations, because there'll be a lot of things that will be commented on that. Emily Neumann has already collected a lot of statistics at her blog and immigrationgirl.com. A survey has been done on how many people are in H4 EAD. I mean, what kind of demographics these people are, what kind of professions, what is the income level, what is their educational background. When these proposed regulations are going to come up, of course, she's going to also give you a draft response to those proposals where you can comment on that. Now, all these comments are going to take a lot of time for the administration to review it, and it might take at least a minimum of 90 days. So at least a minimum of 120 days by the time the regulations might be finalized. Now, that's the minimum. Now, last time when they did publish the H4 EAD regulations, it took almost 1 year for them to publish. So I'm thinking at a minimum of 120 days, at a maximum of 360 days. Now, I might be wrong on it, but that is my best estimate that I have. Emily, on the issue of these H1Bs that have been approved without RFEs, we've been contacted by many clients that they are getting issued a notice of intent to revoke. Their H1B was being filed in the Quota, the H1B got approved without any RFE, and now they are issuing a notice of intent to revoke. Even though the H1 is approved, there is nothing wrong in the application. Is there anything that you want to comment on it?
Yeah, so I don't think we've seen this happen in such a scale before. Last year, certainly, we had lots of requests for evidence for the first time, or way more than usual, bringing up specialty occupation in positions that were generally approved for specialty occupation, bringing up the wage level 1. And with that, we started seeing RFE followed by a second RFE with a different issue. Now this year, we've started seeing in a few cases, or at least we've been consulted on these cases, where USCIS issued an approval early on in the process without any RFE, and then turned around a few months later and issued a notice of intent to revoke, basically saying, we approved this in error, and now because we didn't ask you about X, Y, or Z, now we're going to ask you about X, Y, or Z, and you have to respond in 30 days in order to get your case reapproved. So typically what we're seeing is specialty occupation again being questioned. So they may have gone through the petition and either overlooked something, or maybe they didn't meet their quota for how many RFEs
they're
they
supposed
were
to issue.
Maybe their boss came by and said, you issued too many approvals last month, you've got to go back and revoke them. We don't really know what is going on with them, but it is kind of a new trend that we're hearing about from multiple different sources. So hopefully it's not something that continues to grow. I mean, people should feel like once you get an approval, you should be relatively safe. But USCIS can come back and revoke, or at least they have to send a notice of intent to revoke with the reasons why they think the approval was in error, and give you an opportunity to respond so that you can get that approval.
Emily, with regards to the September 11th memo, which has become effective early this part of the month, where it says that the applications can be rejected without issuing an RFE. Do you see a lot of denials after September 11th? It's been without any RFEs, or is it something that they're going to do only when the application is completely baseless?
Yeah, knock on wood, we're not seeing any issues really with this memo. I do think it's meant for petitions, at least in employment-based categories, where there's just literally no supporting documents being submitted at all. Just a bare-bones petition used as a placeholder until the documentation can be put together. So I think in the vast majority of employment-based cases, especially where the employers are working with an attorney, they should be able to overcome that RFE memo and not have much of an impact. We've not seen any impact so far.
I also want to update for those people whose EB2 and EB3. Now, we have seen that sometimes the EB3 priority date is well ahead of EB2. Now, this used to happen very frequently with Chinese nationals. Now, for the first time, only for the purpose of the filing the adjustment of status, the EB3 has inched ahead of the EB2. So in cases where the EB3's priority date is current, if your EB3 priority date is current but not EB2's, you could use the same labor certification that you have for the EB2 and file an EB3 I-140, and you can file the you can file the adjustment of status at the same time. So if your priority date falls between May of 2009 and October 1st of 2009, and you're in EB2, you haven't filed the adjustment of status, this is a very good time for you to convert your EB3 and EB2 with using the same labor certification without filing another labor certification, and file an I-140 along the adjustment of status. Now, Emily, do you see any pitfalls in filing the premium processing when we're trying to convert from EB2 to EB3?
Yeah, I mean, you're only allowed to submit an I-140 in premium processing initially when you have the original labor certification. So if you're downgrading from EB2 to EB3, you've already submitted that original labor certification in your EB2 filing. So at this point, your only option is to file the EB3 with a copy of the approved labor certification and request USCIS to get the original out of the other file. Because that process takes time, they don't allow any premium processing at the initial filing. Now, once they have actually successfully picked up that other file and transferred it to this file to get the original labor certification out, they do routinely accept premium processing upgrades after that point. Now, how do you know when exactly they've transferred the file? There's no way to know other than by trying to upgrade the case to premium. If for some reason they aren't able to do it, they're going to send that I-907 back with the filing fee, so you're not really out anything by trying to upgrade it. But at the same time, there's not, in my opinion, not a lot of reason that it needs to be processed in premium, because you still have to wait for the 485 to be processed. So they're going to be processed at the same time concurrently. So just because you got your I-140 approved in 2 weeks doesn't mean your 485 is going to get approved in 2 weeks. You've still got to go through that whole processing time. So there's not really a lot of benefit to filing the second time in premium processing in most situations.
Kiran has this question: can a person have more than 2 H1B transfers at the same time? Will it cause any problem when 2 H1B transfers are pending at the same time? No, absolutely, that is not a problem. It will not cause any problem for you at all.
I would caution on that there are some situations where that may look a little skeptical. For example, if you're involved in a third-party placement and one employer is filing a transfer for you to work at a third-party site, and the third party is also filing a transfer for you to work at the third-party site, there's really only one job.
One job, and you're filing both the things.
Yeah.
Whose job is that?
Exactly.
This company or that company?
Yeah, so I think that can be problematic, and I have seen people attempting to do that, so I would certainly be careful in that situation.
I have had my wife on H4 EAD. She is doing a master's degree. Should I apply for change of status from F1 to F1 from H4 EAD? You could apply for the F1 visa from H4 EAD. That's not an issue. But make sure that until the F1 is approved, she is maintaining the legal status. In other words, if the H4 is expiring, let's say in 6 months, and the F1 is taking approximately 1 year, you make sure that you extend the H4 for her until her F1 is approved.
Do you think that there's any issue with the fact that the H4 spouse obviously has an I-140, otherwise she wouldn't have an EAD? Mm-hmm. Does that create an intent issue for getting the change of status to F1 approved? We have not noticed it, though that is a technical rule that's there. That rule is there in the book. If you disclose all the information on the F1 that you have applied for the I-140 for the spouse, I don't think so that I have seen any cause in the problem. That rule is there in the book, that the F1 student visas cannot have an intent to stay here on a long-term basis. Since the spouse's I-140 declared that this particular person probably will immigrate, that might cause a problem, but I have not seen a denials yet. Mm-hmm. You know, the Trump administration is pulling out all the rules that they can. They can always implement those rules, but I have not seen yet. Now, this issue will pop up very much, Emily, when they go to the consulate to get the F1 stamping, though. But I have not seen, if they are doing it within the United States, I have not seen any problem yet. All right, we have a question about kind of what the chances are for approval after an H1B RFE. And it's really difficult to answer that question, because there are some cases after an RFE, I can say there's probably a 99% chance of this case getting approved, because it's a very strong case and it was a simple issue in the RFE, versus other cases it's a weak case to begin with, and the documentation being submitted in response to the RFE is just as weak, or you don't have the documentation they're requesting, then the chances of denial are probably 99%. So it's really hard to give across the board, this is your chance of approval after an RFE. It really depends on the strength of the case as it was filed, what the issue is raised in the RFE, and the strength of the documentation and explanation in the response. But just because there's an RFE doesn't mean it's going to get denied. You can certainly overcome them, with good documentation, but it really depends on the specifics of each case.
Yeah, but there are certain circumstances. For example, if the person has moved, if it's a new quota, the person has moved from client A location to client B, and you're responding to the RFE, it might be almost 100% it's going to be denied. What I want you guys to be very careful, if you can get the things, is that to get the end client letter documented properly, we have noticed that a lot of these end client letters have a lot of errors in those things. If the end client letter does not mention that you are working for your consulting company, that might be a cause for denial. If the end client letter does not mention all the vendors involved in between you and your employer and the end client, it might be a minus point. If the end client letter does not mention that, let's say for example, if it's a software position and it does not mention computer science and a closely related field as a degree requirement, that might be a minus point. I've also seen some of the end client letters which issued that some of the employers draft them, and then probably the end clients draft them saying that the computer science or engineering or any related field, that's definitely a weak point. That I've also seen some of the end client letter assembly that says that the position requires only bachelor's degree as a requirement. Those are very weak things that I'm noticing in the denials where I see. If the vendor letters are not properly drafted, it might be a big minus point. If the company does not have a proper mechanism in having a control over you, that is a good chance of denial. So all those bases need to be covered. That the position requires a specific degree as a minimum requirement, not just a degree, a specific degree, and you have that specific degree, and that the employer has control over you at all times is also a requirement for the H1B to do it. Under the current circumstances, Emily, I'm also noticing a lot of RFEs being issued about whether the person on the CPT, now I'm speaking of a CPT that was issued after they have completed the master's degree, after they have done the OPT, after they have done the STEM extension, they now have a CPT. Now in those RFEs, I've been noticing that there is a consistent denial in the change of status. They are approving the underlying H1B, but they are denying the change of status. Now, what are the strategies in those cases when you see an RFE that has been issued questioning that this person need documentation for maintaining the CPT status? What is the strategies there?
Yeah, now there are a couple of different issues that can come up related to CPT in an RFE. So it really depends on which RFE you're getting on CPT, but if it is specifically talking about the fact that you're using CPT after OPT at the same degree level, there's a very, very high chance that the change of status will be denied because that CPT was not properly authorized. So when we see that in a request for evidence, we're generally recommending to our clients to not attempt a change of status. Let's convert the case to consular processing so that the H-1B can be approved. There's no determination made about any violation of status, and then the person, can exit the country, get the visa stamped, and come back in order to take up the H-1B position. So if you are trying to proceed with the change of status and making the arguments, and you ultimately get the change of status denied, if that denial happens after February 4th, you are unlawfully present for over 180 days from August 9th, and you're going to be barred for 3 years. So that's a very big risk to take. So maybe you can, if you want to give it a try your luck. I hear that all the time, people saying, well, I'm just going to try my luck. Luck is not something that happens to high-skilled immigrants under the Trump administration, I'm sorry to say. You may have been able to try your luck under the Obama administration or in the past, but
Bush
right now, luck does not come into play. People are very unlucky in immigration right now. So anyhow, if you are deciding to provide the documents and make the argument that you're eligible for the change of status, if it's getting into mid-January and your petition is still pending and we won't have premium processing available, which I think is on purpose that it's not available till after
February 4th.
Yeah. So you don't have the option of upgrading. You may want to just consider exiting the country at that point and waiting for the approval outside the U.S. That's just a really big risk to take right now in the current administration.
Now, Emily, did you discuss about the consular option when the RFE is issued on the CPT? What are the negative consequences for those things if the CPT is?
Yeah, I mean, so far in our office's own petitions, we've not seen a negative consequence. I mean, the petition is approved. There's no determination made regarding a status violation. Now, of course, we haven't had individuals going for stamping yet, so that will be coming soon. But when they do go for stamping, there's no issue. They don't have to say that I was found to have violated my status in that DS-160 form because no violation has been determined by USCIS. So I think that's the safer option from a long-term immigration goals standpoint to allow you to get back into the U.S., be eligible for travel, and also be eligible ultimately for the green card in the future.
So if you got an RFE that is addressing about the CPT, that is, we are speaking about day one CPTs after you completed the master's degree, and then this is a second master's though. So you have two choices now. Both of them are bad. I mean, nothing is good. I mean, being on CPT by itself, as you choose to be in that place, at least under the Trump administration. So if you choose to not argue, not contest the issue of the legal status on the CPT, you could go for the consular processing. And of course, there's a risk there that you might be getting the denial in the consulate. Now, the other chance, as Emily was pointing, you want to risk yourself and contest saying that CPT is fine, you're maintaining the legal status. Now, what we're noticing is that in the past 1 week, consistent denials for those people who challenge the USCIS questioning that they maintain the legal status on the CPT, that they could work on CPT and day one CPTs, even though they are attending only 1 day a month in the class and their CPT is valid. We have noticed that almost every change of status is getting denied. Now, what happens here is that the risk is manifold here, because once the USCIS determines that you are out of status, you are now actually going to the consulate. Now, if you're going before February 4th, you have at least a chance to go. If you go after February 4th, you have a 3-year bar. You just cannot go for the consulate for stamping. If you go before February 4th, you have another extra burden. You have the immigration service telling you that you're out of status all along on the CPT. Now you're going to the consulate and telling that, well, look, give me the H1B status. So now, even though the immigration has told me that I am out of status, give me the H1B. You look very weak if your change of status has been denied, as compared to if you opt with the consular processing, where the USCIS does not determine that you're in status or out of status, then you take your chances at the consulate. If you have an RFE based on the CPT, I would advise that you make an appointment with a competent lawyer and discuss the options. Do I take the option where I'm going to challenge the status issue, or I'm going to just go for the consular processing? This has become very important. From the beginning, we have advised to take the second option. But now, in the past 1 week, I'm looking at so many denials that I'm getting consultations where their change of status has been denied. Now, I want you guys, even if your change of status has been denied, I want you guys to be very careful. Please consult with a competent lawyer, because how you're going to answer the questions in the consulate when you go there, especially when the USCIS has denied it.
All right, one question that's been coming up a lot lately with the premium processing suspension is, how are H-1B transfers working? So typically, before, when we had premium processing, the individual would file the change of employer petition in premium processing. Once it's approved, then they start working for the new employer. Now, you're not required to do that. Under AC 21, your H-1B is portable, meaning that based on the pending transfer, you could actually join the new employer. But what happens if you join the new employer based on the pending transfer and then it gets denied? really kind of depends on what's going on with the previous employer's petition. Number one, has that I-94 expired? Has that employer withdrawn? And do you have the option of going back to that employer? So there's a provision called the dormant H-1B. It's kind of an old guidance letter. It's not really anything in the regulations. But it basically says that you have an approved H-1B, and that approval is going to remain valid until it's either expired or withdrawn. And if you file a transfer to another employer and get another approval, you have two approvals. That doesn't make the first one go away. So you technically have a dormant H-1B that you could possibly go back to. The same may be the case in the event of a transfer denial. You could get your status back potentially by going back to the previous employer. Now, the next question I get is, well, what if I can't go back to that previous employer? Can I file another transfer after my first transfer has gotten denied? Now, that is going to be a problem because anything you're filing with USCIS, you always have to prove on the day of filing that you were in status. Well, when your transfer is denied, the day of the denial, you are out of status. You're no longer in status, and therefore you have no status to transfer to a new employer. No. You have no status to change to another type of visa. So that can be a very risky situation to be in. And unfortunately, with premium processing being suspended, your choice is to wait 6 months to get the approval before you join that employer, or take the risk and join them and hope that it gets approved. Now, you can certainly improve your chances by choosing the right employer, choosing the right kind of job opportunity for you that makes a strong case. You don't want to pick a weak type of H-1B case to file a transfer with and end up out of status because of it. So choose your employer, choose the job opportunity very carefully if you're looking at transferring based on the pending petition.
There's some good news for those people who change of employer gets denied, that even if the I-94 expired, when the change of status, change of employer gets denied, the unlawful presence does not count from the time the I-94 expires. It counts from the time the denial has been issued, unless the transfer application is a frivolous application. So the unlawful status actually count from the time of denial. As we have mentioned before, the August 9th memo has changed the situation. When does the unlawful presence count? But that did not change the situation for the people who have applied for the change of employer. It only changed for the student visas. Particularly for those people on the CPT, I'm very worried that the August 9th memo is effective right now. They are saying that if the change of status for the CPTs has been denied, it goes back to the day 1 of CPT or on the day of August 9th, whichever is later. So I'm more fearful that the unlawful kick in more for the F1. I'm not that much worried for those people whose change of status get denied, change of employer gets denied, and now they are leaving. The unlawful presence will only count from the day of denial, and if the unlawful presence is less than 180 days, there's not much penalization for it, and if they leave it within a week or 10 days, I'm not that much worried about those people whose change of employer gets denied.
All right. One other issue that comes up with October 1st being right around the corner, for those of you that filed in the lottery and already have your H1 approved or it's still pending, is your dependents, your spouse and children. If they're in the U.S., be aware that their status does not automatically change just because yours did. A separate application is required for your dependents. So if you're in that situation where you've got your H1 approval or it's pending and you have dependents in the US, maybe they're on F2 or L2, you need to file an I-539 application to change their status as well. And if you haven't done it yet, you really need to do that as soon as possible. It should be filed
before September 3rd.
Yeah.
Before October 1st, you need to file the change of status application. And if the H1 is already approved for you and your dependent is another visa status and they're counting on it, if you apply after October 1st, they will be considered to be out of status. You are in a big, big danger. We want one more time, if your H1B has been selected and if your H1B has been approved, you need to file the application before October 1st, especially for those people whose H1B is already approved. And for those people whose H1B is still to be adjudicated, we still recommend that they do file before October 1st.
We had a proposed regulation recently. We've got lots of proposed regulations coming up, but another one that I wanted to discuss is this public charge issue. So, generally, whenever someone is applying for a visa at the consulate, they're applying to be admitted into the U.S. at a port of entry, or they're applying for permanent residence, the person has to prove that they will not be a public charge. If you are going to be a public charge, that's considered a ground of inadmissibility, meaning you are not admissible, cannot be admitted into the U.S. in that type of visa at that time of entry or to get your green card. So this has been in the law for a very long time, but now the Trump administration is proposing a new regulation to expand how they determine public charge, and on top of it, what's really interesting, which I realized this right before we came to start our video for today, is even though it's not in the statute, they're going to expand it to change of status and extensions of stay in the U.S. So this does impact H1, this impacts H4,
H4s,
F1,
L1s,
O1, L1, pretty much every alphabet this is going to impact. So now they're proposing this big chart that gives you the various factors that they're going to look at to make a determination about whether you're admissible or not under the public charge ground. They're going to look at your age. So if you are between 18 and 61, that's a positive factor in the eyes of the Trump administration. Congratulations, you're not too old to come here or too young. They're going to look at your health, so that if you currently have a medical condition that may cause financial stress to you now or in the future, that is a negative factor that they're going to look at. They are going to look at your credit score. They're going to look at how many loans you have. Do you have a mortgage? Do you have a car payment? Do you have too many credit cards? And they're going to use that as a negative factor in assessing whether you're going to become a public charge. They're going to look at all of your assets. They're going to look at your income, your household income, the size of your household. Oh, maybe you have too many kids to support on the income that you're getting. That's going to be a factor. That's kind of been there, but they're expanding it more for employment-based. And then they're going to be looking at your education. Do you speak English well enough to be able to survive in the job market here in the United States is one of the factors. So they're going to take all of those, and then they're going to decide whether it's a positive or negative factor, and then decide how much weight to give to each individual factor, and then come up with an overall, if the negatives outweigh the positives, you are inadmissible based on the public charge ground of inadmissibility. Now this is a 400-some page regulation. I would assume there's plenty of U.S. citizens out there that have poor credit, low credit scores, and I understand that. I understand the purpose of the public charge. They want immigrants who are coming into the U.S. to be able to, support themselves and their family. That's totally understandable. However, this gives so much discretion to the USCIS officer to just decide, this credit score is a little too low. I don't think I'm going to approve this person's change of status, or I'm not going to approve their H1B extension because of a bad credit score. It's just ridiculous. And I don't know how USCIS officers will have the time to pull someone's credit report and go and look at all of these different options when they're already taking a year to process an H4 extension.
Well, they can do one thing, Emily, is that right? They can have a stress test. When I go to the heart doctor, they have the treadmill, and then they have to make you run there.
How are they going to look at your medical history?
And then see all the testings. I don't know if they're qualified. I'm not sure based on what you're telling, Emily, where Melania Trump's parents are going to be qualified to get in because they're above 61.
Yeah, exactly.
And
So this is just a proposal, so not to scare anybody, but it is open for public comment. So definitely, we'll probably be working on a public comment, a draft for people to submit for that, just on the absurdity of the level of detail they're going into in a simple extension of stay for an H1. The person could be making $100,000 a year, clearly able to support themselves and their family, yet it might not be good enough if they've taken out too much credit card debt or have student loans, or
maybe he has a propensity for a heart attack or maybe cancer.
Right, yeah. I don't know.
It's very tough.
So keep an eye out for that.
Emily, this Hitesh has this question, which is kind of, he's saying that the I-140 has been approved, but the extension getting denied. I think so. I just want to clarify it more clearly than ask you the question, though, because if the I-140 has been approved and it's not been withdrawn, the extension because of 7th year extension will never be denied because of that reason alone. If the I-140 is approved, it's not been withdrawn, and if H1B extension will not be denied. But keeping that in factor, Emily, my question to you is that if the I-140 has been approved, can the H1B extension be denied for any other reasons? Absolutely. And if so, since they're eligible for the 3-year H1B extensions, is it required? Can they deny the 3-year H1B extensions?
Yeah, absolutely. So just because you're eligible for an extension of up to 3 years doesn't mean they have to grant your extension if you don't qualify. So they're, again, going to be looking at, is this job a specialty occupation? Do you qualify for the position? Is there sufficient specialty occupation work available? Have you maintained your status properly up until now? Have there been any other violations? So just having an approved I-140 does not guarantee anything in regards to getting that extension beyond the 6-year limit. All aspects of your eligibility for the H-1B still have to be met in order for an extension beyond the 6 years based on the I-140 to be approved.
Building number has changed. Do I need to file an amendment of the H-1B?
I think that's probably not a material change. It's within the same MSA. The prevailing wage is not going to be impacted by that. So that generally would not require an amendment. However, it's a very good idea for the employer to update their address with USCIS, because a site visit officer might not be aware that the company has moved, and a site visit could go awry in that situation where they think the company no longer exists because no one was there at that location.
Cookie has this question. My husband is a business analyst, and I-140 is approved, and now he's going for an IT manager. Does he need to file a PERM application again? But the answer to the question is, it looks to be a natural progression in the job, according to me. I don't think so. It requires another PERM and I-140 for this person, moving from a business manager to IT manager.
Yeah, I think it really is going to depend on the specifics of the two jobs. But it is something that you should be speaking with the attorney that's been handling that company's cases to determine whether that a new PERM is required or not.
EB1C was not current in October visa bulletin. Yes, it's not current. Yes, we thought that it would be current, but it's not current. I'm sorry. We go wrong in predicting the visa numbers so many times. We went wrong, and it's very hard to predict the visa numbers. EB1C, if it's not current at this point of time, having it being current in this year, remember the year start on October 1st. So we already have the visa numbers for the October 1st. For this year, that means that October 1st to September 30th of 2019, for it to be current, to be the present date, for the Indian nationals, I don't think so. It will be current.
An EB1?
EB1.
Yeah. Yeah, I mean, if we're already not current and they're saying no movement until January at the earliest, I think there's probably a substantial number of applicants out there who've already filed and couldn't get approved last year because they ran out of numbers.
And there's a difference between the Department of State EB1 and the USCIS EB1. So the Department of State is 2016 and USCIS right now is at 2017. Normally, when there is a two cutoff dates, USCIS always goes with the oldest cutoff date, but only in the month of October, and very rarely sometimes they do it. They go to the later part of it. So most probably there will not it will not be like that going forward in this year, though.
Yeah, and lastly on that, a lot of people ask about the 485 inventory report that USCIS publishes. You have to be aware that because of the interview process for employment-based cases now, the data in that inventory is only for cases pending at the service centers. Once it gets transferred to a local office for the interview process, it's no longer going to be on that chart. So I think that there's probably a large number of cases out there that are still pending but are not on that chart because they had already been transferred to the local office. So I'm not really sure how useful that chart is anymore.
I would recommend that you go to an article that we have published in rnlawgroup.com. It says 108 years for you to get the green card if you were filing in February of 2018, which later on an institution which has a little bit more funding than us proved that we are wrong by about 42 years. They said it's 150 years. But you can have all the statistics that we have given, 108 years for you to get the green card in the news articles.
All right, I think that about wraps it up for today. If we did not get to your question, or if you want more specific information about your situation, you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com. Stay tuned to Reddy and Neumann PC's Facebook page for updates as well. And you can always find me on Twitter at ImmigrationGirl or by going to immigrationgirl.com and subscribing. There you'll get the latest articles every time I post them. Thanks for joining today.
Thank you.